Good afternoon, everyone. This is John Bonifaz. I'm the president of Free Speech for People, and I want to welcome you all to this discussion defending our democracy, looking back and looking forward with respect to election protection. We're pleased to have this discussion with all of you today. We're going to be focusing on a few key cases of our litigation docket last year and moving forward, and then we're going to talk briefly about our plans as we go forward this year in protecting our elections and defending our democracy. I'm pleased to start off this discussion with Courtney Hostetler, our senior counsel. Courtney will discuss two of our cases, one of which is still pending in North Carolina, challenging insecure and unreliable voting systems, and one in Texas, which we litigated last year to challenge unsafe and unequal voting conditions. Courtney?
Thank you so much, John, and thank you everyone for being here. As John mentioned, I'll be talking about our lawsuits in Texas and North Carolina, and what they share is a focus on our attempts to make sure that every voter has the right ability to vote in a manner that is secure, reliable, and safe. Because during the pandemic, it became very clear that free and fair elections hinged on voters' access, not just to reliable voting methods, but to safe voting options. So in Texas, we brought a lawsuit in federal district court to challenge a number of laws and practices in Texas that made voting in person difficult and dangerous. We worked with pro bono counsel Leif Cabraser, Hyman, and Bernstein, as well as pro bono local counsel Lyons and Lyons to represent Mi Familia Vota, which is a civic engagement organization that supports Latinos in a number of different areas, including voting and elections. We also represented the Texas NAACP and several individual voter plaintiffs who went into these elections facing an untenable choice of having to either vote in person and put themselves at serious risk of infection from COVID-19 or stay home and essentially give up the right to vote. Even before the pandemic, Texas election policies burdened voters. It had limited excuse-only absentee ballot laws. It had closed more than 750 voting locations since 2012, with the vast majority of these closures affecting Black and Latino communities. And in 2019, just a month or two before the pandemic hit, it actually prohibited counties from using mobile early voting sites to reach communities that didn't have access to the central early voting sites, which meant many people from nursing homes to rural communities to university students could no longer really access early voting. Many counties in Texas also use insecure and unreliable voting machines and do not give voters the options of voting by hand-marked paper ballots. The results were bad, again, even before the pandemic. During the March primaries, for example, which took place, I think, 2 days before the first COVID case hit Texas, resulted in many people waiting in line for hours to vote. And they had much less of a turnout than you'd expect in a general election, right? Usually there's 4 to 5 times as many people voting in the general election, and people were still waiting for 4 or 5 hours to vote. And unsurprisingly, the distance that voters had to travel to polling locations and the amount of time that they had to wait to vote was longer for people of color in Texas. So these laws put an even greater burden on the right of voters during the pandemic. During the summer and well into the fall, Texas experienced a wave of COVID-19 cases. Black and Latino communities in Texas were at heightened risk of infection and serious illness from the virus due to systemic inequality like unequal access to healthcare, insecure housing, and the fact that people of color were more likely to be working in essential services. Crowded polling locations, long lines, and limited voting locations, particularly in communities with rampant outbreaks, posed a very serious risk to voters. Despite this, Texas really did not move to make voting safe. The state refused to expand absentee voting. It exempted polling places from the statewide mask mandate. It refused to expand the use of hand-marked paper ballots, which were safer to use than machines and resulted in shorter lines. And it prohibited counties from taking steps to protect voters on their own. Our lawsuit challenged a number of Texas laws that made voting in person unsafe. The lawsuit brought immediate attention to some of the serious deficiencies in Texas's in-person voting plan. Soon after we filed our lawsuit, the state did address one of these issues, the lack of sufficient early voting, by expanding the early voting period. But this was not our only victory. Although the district court initially dismissed our claims, the United States Court of Appeals for the Fifth Circuit disagreed and held that our plaintiffs were entitled to bring their Voting Rights Act claims that challenged Texas's dangerous voting laws. The district court then granted our renewed motion for preliminary injunction and found that the governor's decision to exclude voting places from the statewide mask mandate violated the Voting Rights Act and discriminated against Black and Latino voters. Unfortunately, on the eve of Election Day, the Fifth Circuit stayed this decision. Despite this, we were encouraged that the Fifth Circuit recognized that the Voting Rights Act is an appropriate vehicle for addressing these issues. And furthermore, that the district court agreed that the relief that we sought was both practical and reasonable. Now, because Texas was a pandemic-specific lawsuit, we have since dismissed the case as moot. But elsewhere, issues related to insecure voting are ongoing, and so are our lawsuits. And one of these ongoing lawsuits is in North Carolina. In North Carolina, we are working with the Lawyers Committee for Civil Rights, as well as pro bono counsel Shepard Mullen, to represent the North Carolina NAACP and individual voters. We have brought that lawsuit in state court, and we're challenging the use of the express vote by 21 counties, including Mecklenburg County, which is the most populous county in the state. The express vote is an insecure, unreliable, and unverifiable voting machine. It's a ballot marking device. And the way it works is by requiring voters to make their selection on a computer screen. Once they've done that, the computer will print out a piece of paper that has two sections on it. One is a list of the voters' choices, and the other section is a machine readable barcode that is supposed to reflect the voters' choices and be identical to the choices contained in the list. Voters will then bring this piece of paper to a tabulator, insert it, and the tabulator will then tabulate the vote, but the machine will only read the barcode. That's how the machine figures out supposedly what the voter chose, and that's how they'll tabulate the votes. The problem is that voters can't read the barcode, which means voters don't really have a way of reviewing what data is getting counted. And the text printout is also limited. It'll be a very short, abbreviated list, and it doesn't contain the same kind of information that a voter who has a hand-marked paper ballot to review might have in front of them, right? So it might have just a number instead of the actual question on a ballot question, for example. It wouldn't necessarily list all the candidates. It would only list the candidate that person chose. And that can get complicated and difficult for voters who are looking at a long ballot and have a lot to remember. The machine is also insecure. It's not just unverifiable, it's really an insecure machine. Multiple versions of the express vote are unfortunately in use across the country, and they've been found to be flawed and vulnerable to being hacked. The machine also features software that has already passed the end of its life. It was a few months from passing the end of its life when North Carolina chose to certify and allow these machines to be purchased. Now, Microsoft did offer security patches to protect the machines during the 2020 election, but that period is now over, and no additional patches or security are going to be offered on this software that is now powering machines that could be in use in North Carolina, for years to come. These issues are not just about the security of the machine, it's also about voting access. When you have a malfunctioning machine, it can lead to delays that interfere with voters being able to get to the polls. And we have seen this happen where machines start breaking down, lines pile up, and you have people again deciding, do I stay in line during a pandemic? Do I miss more work? Or do I go home and now not have the chance to vote because machines were breaking down? And this problem, again, not unexpectedly, is going to be worse in counties that might not have the money or the ability to buy enough machines to support its population. Nobody should have to wonder if the choices they made were the choices that were actually cast and counted. And no one should be forced to wait in line because of machine malfunctions or shortages. This really means in practice that paper ballots should be made available to all voters. And then anybody who requires or prefers assistive devices to vote should be able to vote on machines that are as secure as possible and subject to rigorous oversight and accountability measures. And unfortunately, that hasn't happened in North Carolina. And the failure to do that violates North Carolina's constitution, which has protections for free elections. Too many voters are being required to vote on these insecure machines. At this point, our lawsuit is still in its early stages. We did obtain an early partial victory in which the trial court rejected the defendant's argument that our case should be dismissed. We are committed to pursuing this lawsuit, to defending against additional motions to dismiss. We'll be seeking discovery, and we'll be moving our client's case forward toward a resolution that will hopefully afford them a safe and reliable means of voting.
Great. Thank you, Courtney. Our next speaker is Ben Clements, our board chair and senior legal advisor. Ben will discuss two other cases we litigated last year and into this year in Minnesota challenging illegal voter intimidation and in Arizona extending the voter registration deadline. Ben?
Thank you, John, and thank you, Courtney, and thank you to all of you for attending and for your support for Free Speech for People. I'm going to start with the Arizona case, and before I get into the specifics of the case, let me give a bit of background. As we all know, voter suppression is not something that happens by accident. It's a political strategy, excuse me, and it's a strategy used by a party that increasingly depends upon skewing the electorate in order to win elections. So there's a variety of ways that states suppress certain aspects of the electorate. One of these is by making it more difficult to vote. And one of the ways they do that is by onerous voter registration requirements. So in many states, there's an effort to make voting easier. And in some states, you can register the day of the election. You just show up. If you're not registered, you register on the spot and you go ahead and vote. But many states resist efforts to make it easier to vote. And one of the ways they do it is by imposing a deadline. Arizona requires voters to register almost a month before the election. And this is a problem that during 2020, like most problems, was made much worse by the fact that we were having this election in the midst of a pandemic. In a typical election year, voter registration efforts begin at the beginning of the year, and they continue right through the registration deadline. So voter groups are knocking on doors, holding registration drives, and helping people to register. In 2020, these efforts were well underway. During the first 3 months, tens of thousands of new voters in Arizona were registered to vote. But then at the end of March, because of the pandemic, the state of Arizona issued a stay-at-home order, and these efforts essentially stopped. They didn't resume until late August, when the restrictions began to be lifted. So we decided, with the loss of many months of registration efforts, to ask to extend that deadline. The Secretary of State of Arizona was not willing to do that voluntarily, so we brought a lawsuit. We sued on behalf of two voting rights groups, Mi Familia Vota and Coalition for a Change in Arizona. And we brought the suit in federal court, arguing that the registration deadline in the context of the pandemic, and in particular the shutdown orders, represented an unconstitutional burden on the right to vote. So we asked the court to extend the deadline from October 5th until late October to allow more time to register. The Secretary of State, the Attorney General, and the Republican Party all opposed our efforts, but the federal judge agreed with our position and granted our motion, extending the registration deadline to October 23rd, excuse me. The defendants took that up on appeal, and the appellate court effectively shortened that extension to October 15th. But during those additional 10 days that we received from the court to register people to vote, an additional 35,000 Arizonans were registered to vote and able to vote in the 2020 election. This was a significant and potentially decisive additional amount of voters in a state that Joe Biden won by just over 10,000 votes. So we this case represented a huge victory for the state of Arizona, but as I said, potentially a difference maker in the presidential election. While we were litigating that suit and several other voting rights suits around the country, we learned in early October from a Washington Post article that a so-called private security firm located in Tennessee had been recruiting former federal military special operations forces to serve as poll monitors in Minneapolis and St. Paul on election day. The chair of this organization, called Atlas Aegis, gave an interview to the Washington Post in which he said they intended to send these armed former military personnel to patrol the polls in order to protect the polls from Black Lives Matter protesters and so-called Antifa. Now, this obviously was before the insurrection on the Capitol that Donald Trump inspired to try to block certification of the election. But it was many months after Donald Trump had begun his campaign to persuade the electorate that the election was rigged against him and had begun urging armed vigilantes to interfere with voters. In fact, it happened just several days after he had reiterated his claim that the election would be rigged against him and asked the Proud Boys to stand by. So these threats and this plan was real, and it was intimidating. And it also violated the Federal Voting Rights Act that prohibits intimidation of voters. Now, the context of this, aside from Donald Trump's urging of vigilantes to interfere with the right to vote in Minnesota, was this is several months after George Floyd had been murdered by the Minneapolis Police Department, resulting in racial justice protests around the world, including major protests throughout the months in Minneapolis and in St. Paul. And so it was quite clear what group of voters Atlas and its chair were attempting to intimidate when they focused on Minnesota's urban centers and Black Lives Matter supporters. So we decided to file suit under the Voting Rights Act. We brought our suit on behalf of two Minnesota organizations, the League of Women Voters of Minnesota and the Coalition for American Islamic Relations in Minnesota. And we argued that the defendants' conduct, both the threat that was issued in the Washington Post, which in itself is a form of intimidation, and their plan to actually have armed vigilantes at the polls, illegally intimidated voters in violation of the Voting Rights Act. And we asked the court to issue an injunction stopping them from promoting their plans, from carrying through with their plans, and preventing them from putting any armed officials anywhere near the polls in Minnesota or otherwise intimidating voters. Just a week before the election, a little less than a week before the election, and just a couple weeks after this first emerged in the Washington Post, a federal judge granted our motion, granted the injunction completely, and ensured that Minnesota voters were able to vote at the polls without fear and without interference from armed mercenaries. Our major goal in this case was to address the threat to the 2020 election, but we were looking beyond that, and we asked for relief against the defendants for future elections. And when we made clear to the defendants that we intended to proceed to trial to seek a permanent injunction against them, they agreed to enter into a consent decree, which stops them from sending armed personnel to anywhere within 250 feet of a place that votes are being counted or votes are being cast, and that prevents them from interfering in voters' rights in coming elections. So this is a victory not just for 2020, but going forward, and not just for Minnesota voters, but voters across the country, as the case sets a very important precedent and provides a model for future Voter Rights Act litigation to protect voters from armed vigilantes. So with that, I'm going to turn it back over to John Boniface.
Great, thank you, Ben. So before we start the Q&A session, I just want to make a few brief comments on our work going forward in this space of election protection. Into this year, we plan to be very vigilant in focusing on what's happening in the states. As we know, there are a number of bills that have been introduced before state legislatures across the country to roll back voting rights, to make it more difficult for people to vote. And we're watching closely what's happening with some of these bills, and we are preparing for the potential to need to go into court to challenge these laws if they get enacted for being unconstitutional and in violation of the fundamental right to vote. That's one main area of our election protection work going forward. Another main area is around continuing our work in the North Carolina case, in a companion case in Pennsylvania, challenging insecure and unreliable voting systems. And we are about to initiate a new election security case in the near future. And a third area is picking up off of what Ben just described from the Minnesota victory, is using that victory as a model for how we can challenge voter intimidation across the country. We want election officials and elected officials to at all stages of government to know about this consent decree the court has ordered and to see it as a model for how to address these kinds of threats in their respective states. So those are three of the main areas of our election protection work. Obviously, as you all know, we also remain vigilant in challenging big money in politics and unchecked corporate power and in confronting corruption in our government, including accountability for the corrupt abuses of power we witnessed in this past administration.